Now, the record is already pretty big, as we talked about the D-ring binders before. So we didn't make it any bigger by introducing a whole bunch of testimony and exhibits on the spread between supervisors and everybody else in all the job series. But the problem extends beyond just the CO sergeant issue. It's pretty much system-wide. If you look at it, Union Exhibit 3, you can look at the last 2 pages of Union Exhibit 3, and we lay out in that exhibit all the classifications where we believe the increase is warranted. I want to talk briefly about shift premium and on-call pay. Really something of a separate issue here. These are easy and inexpensive and important fixes to a significant problem. Michelle Woodrow, you may recall, was asked to prioritize the union's proposal, and she explained that without question the #1 priority is the prison premium and elimination of the GO-pay. And then she went on to rank some of the other ones. But she carved out these 2 issues that are kind of unique to the healthcare workers. And she explained that they were different, unique. The medical staff at the Department of Corrections is a different group. They don't typically get involved in union activities in quite the same way as the corrections officers and other custody staff. They don't typically have a lot of contract disputes, and they don't get involved in disciplinary grievances as much either. The one thing that we have consistently heard from them, pretty much the only thing that we've consistently heard from them, is about this equity problem with the shift premium and the on-call pay. Michelle Alejo testified that the LPNs perform the same work as the nurses on the weekends. So there's no reason they shouldn't get the weekend premium. Sandra Connor, she testified about that $25 she gets for daily on-call pay. She talked about the impact that being on call has on her life. She can't travel, she can't go hiking out of cell range, she can't go boating, swimming, can't really drink on her days off. She's basically tethered to a phone and she has to be accessible. Now it's worse when they're understaffed, which is kind of a chronic problem because they then have to pick up an extra week to cover for the vacant position. An extra week of call, and there's simply no reason why she should get $25 when contractors doing the exact same work are getting $125 or $150. Now the cost of these 2 proposals is a drop in the bucket, but it's a very important drop for a very important group of workers who have asked for little else. The state has basically one major argument in this case. The state's argument is ability to pay. You know, in the public sector, it's well understood that ability to pay really means willingness to pay. The state can raise the revenue to cover its expenses. This is about legislative choices and prioritization. It's about our elected officials having the political courage to do what's right and necessary to pay for what we as a society have decided to do with people who break the law. Now, if there's any doubt about this, it's now clear in the record through the testimony of Mark Andreessen and Union Exhibit 62. If you look at Union Exhibit 62, you see that all the other Western states, with the exception of Alaska, spend a larger percentage of their total budget on corrections than Washington. And actually, on average, they spend twice as much as Washington. We spend about 3.6% of our budget on adult corrections. The average of the other states combined is 7.5%. So twice as much. But it wouldn't actually take doubling the DOC's budget to
What was the Washington number again?
3.6%. Washington is 3.6%, and if you look at the other states and average them, it's 7.5%. But the union's proposal is $120 million, essentially the entire proposal, $120 million, which is 7% of the DOC budget. Not 100%. It's not a doubling. If you funded the entire proposal, the entire union proposal, at $120 million, That's $120 million on a $1.7 billion budget across the biennium. It's not insignificant, but it's not impossible to fund. The union's proposal is well within the norm when compared to what other states spend. Now, we're not pretending that the state doesn't have a decent argument on the ability to pay factor. We're not suggesting that the state has no money problems. But it's only one of several factors. It's not the only one. The other factors weigh in the union's favor. On comparables, under anybody's analysis, under anybody's methodology, Washington DOC is way behind. Their current wages and benefits and the loss to that earning power over time. They haven't had any wage increases for years, and they've had nothing but cuts. We heard lots about the difficult reality of working in prisons, and we heard about retention problems. The ability to pay concept, that factor, it's one factor with no more weight than any of the other factors. It's just not a trump card. And there's lots of arbitral authority on this issue. For example, Arbitrator Latch in 2011 in a Lewis County case, he in his award, he said, while the arbitrator should consider the employer's economic condition as a factor to be applied, it is not the only factor to be considered and must be analyzed in light of the statutory factors, which is exactly what I'm saying. It's one of several factors. Arbitrator Williams issued an award in 2009, which was a relatively dark time for public sector interest arbitration in the city of Longview. And he said, ultimately, the arbitrator set aside his trepidation, focused on the statutory criteria, and notes that for most all of the comparators' wages and benefits are already set through the year 2011. This award is, in the arbitrator's view, consistent with the terms and conditions set forth in labor agreements of the comparators. Hopefully, actions taken at the national and state level will continue to have a positive impact on the economy, and business can return to a more steady state. Clearly, this award contains some of the optimism found in that statement. He was issuing an optimistic award in 2009. That was a dark time. We're past that. There's plenty more arbitral authority available, I guess, upon request if you're interested. But the point is that arbitrators don't refuse to issue otherwise justified awards just because the employer cries poverty. And it's not all bad. It's not. Revenue forecasts are positive. You can see Union Exhibit 44, which demonstrates that the general fund, during the same 6-year time frame when the employees got absolutely nothing but cuts, the general fund has increased by 20%, and our annual revenues have increased by 20%.
41 was it?
44. And Exhibit 45 shows that the overall economic analysis is that general fund revenues are on the uptick and will continue. Ability to pay arguments in general are more accepted by arbitrators during periods of severe economic downturn. That's a Pierce County case from Arbitrator Krebs, noting that that's an important time to look at it. But things are getting better, not worse. We are on an upward trajectory. But again, willingness to pay is not a trump card. There's nothing in the MOU or the law that suggests there's some magical significance to the fact that it's listed first out of a series of other factors. It's there, and it's something to consider. In conclusion, the MOU says that the decision of the arbitrator is not binding on the legislature. As you mentioned, OFM still has to find it financially feasible. So we want an honest answer to two questions. First, what does this group of dedicated public safety workers deserve in light of the compensation deficiencies, which are measured against comparable jurisdictions, the DOC's recruitment and retention issues, the losses sustained relative to cost of living over time, and most importantly, the danger and difficulty and impact of working in a prison environment. And second, in light of the state's financial situation, what can be accomplished within the context of a 2-year deal? You could say that we're asking for a decision that says, in the absence of an ability to pay issue, my decision would be X. Given the ability to pay issue, my decision is Y. but Y cannot be what the state is proposing. All of the union's proposals are justified and important. Finding the money to pay for it is really a matter of legislative priorities and political will to fund the decisions we make as a society.